We have a very bad regulation that's been put out by Social Security Administration that needs to be obliterated, and so we're using the process called the Congressional Review Act to show Congress's displeasure with Social Security and to get this regulation off the books. Now, there's been a lot of talk about how this Congressional Review Act is a wrong vehicle to repeal the disastrous regulation. So I want to quote a contrary opinion from the National Coalition for Mental Health Recovery saying this, quote, "The CRA," meaning the Congressional Review Act, "the CRA is a powerful mechanism for controlling regulatory overreach, and the National Coalition for Mental Health Recovery urges its use advisedly and cautiously. In this particular case, the potential for real harm to the constitutional rights of people with psychiatric and intellectual disabilities is grave, as is the potential to undermine the essential mission of an agency that millions of people with and without disabilities rely upon to meet their basic needs. Therefore, in this instance, the NCMHR feels that utilizing the Congressional Review Act to repeal the final rule is not only warranted, but is necessary," end of quote. And I would add to that, obviously necessary. So, Mr. President, I'd like to enter that letter into the record.
Without objection.
There's also been talk about how supposedly dangerous it will be if this Social Security regulation is terminated. I don't see how that can possibly be realistic if the Social Security Administration doesn't even determine a person dangerous in the first place, and dangerous in regard to whether or not they ought to be able to make use of the constitutional right of Second Amendment to own and possess firearms. Now, others in this debate continue to mention that mentally ill people will be able to acquire firearms. Now, very important, the Social Security Administration does not determine a person to be mentally ill prior to reporting their names to the gun ban list, which, being on the list, denies you your constitutional rights. The agency has confirmed this in writing to my office. Quote, "Yes, you are correct. The Social Security Administration does not diagnose individuals as mentally ill," end of quote. Supporters of this gun ban fail to address why individuals are not provided formal due process before reporting their name to the list. Supporters have also failed to talk about how the regulation is inconsistent with the statutory standard of quote-unquote mental defective. An existing statute requires agencies to report individuals to the gun ban list who are ineligible under current law from possessing firearms. That requirement does not require the existence of any regulation to be effective. So it is plainly wrong to claim, as was said this very day by the people opposed to what we're doing, that if the regulation is disapproved, agencies will no longer have to report prohibited persons. The reverse, in fact, is true. The regulation usurps unlawful authority to report people to the gun ban list who are not barred from owning guns under current law, and that the agency is prohibited from reporting under current law, especially without the adjudication that is required under current law. Opponents of the regulation base their opposition on the language of the regulation, existing law, and the Constitution, citing the Constitution to say you don't have a constitutional right to own arms under the Second Amendment is contrary to two recent Supreme Court decisions that verify that that applies to an individual. That is why the regulation's supporters must resort to arguments that lack legal and factual foundation. Supporters of this gun ban also fail to address how overly broad this regulation is as written. It will capture innocent Americans, denying innocent Americans their constitutional rights. And sadly then, we know how this will play out if this regulation were allowed to go forward, because we have the example of the Department of Veterans Affairs reporting hundreds of thousands of veterans to the National Institute criminal background check system without adequate due process. And that's the same system that Social Security was going to report people to. Now, veterans were reported just because some lonely bureaucrat wanted to report them with no opportunity to first have a neutral authority hold a hearing finding that that individual is dangerous or actually have a dangerous condition. These were veterans that needed financial help managing their benefit payments. Now, it's common sense that needing help with your finances should not mean that you have surrendered a fundamental constitutional right of self-defense that you have under the Second Amendment. So just like the Social Security Administration, the VA does not determine whether a veteran is dangerous before reporting his name to the gun ban list and denying that veteran his Second Amendment constitutional rights to own and possess firearms. The VA regulation is eerily similar to what the Social Security Administration wants to do. On May 17, 2016, Senator Durbin and I debated my amendment that would require the Department of Veterans Affairs to first find veterans to be dangerous before reporting their names to the gun ban list. Now, that's common sense, isn't it? You ought to find out, are they really dangerous before they're denied a constitutional right? During the course of that debate, Senator Durbin admitted that the list was broader than it should have been. He said, and I quote, "I do not dispute the senator from Iowa suggested that some of these veterans may be suffering from mental illness not serious enough to disqualify them from owning a firearm, but certainly many of them do," end of quote. Senator Durbin also said, quote, "Let me just concede at the outset, reporting 174 names goes too far, but eliminating, as my legislation proposed to do, eliminating 174,000 names goes too far." For the record, though, it wasn't really 174,000 names going too far. It was actually 260,381 names from the VA sent to the gun ban list. Now, that happens to be 98.8% of all names that are on the list because of alleged mental defectiveness. The Department of Veterans Affairs reported more names by far than any other agency without sufficient justification. Senator Durbin's staff and mine have met over these issues since that debate, and I appreciate and thank him for that outreach. But now we have this Social Security Administration problem, and through the Congressional Review Act, we can do something about it. We don't have to pass a separate piece of legislation like we're going to have to do to straighten out the VA. So the Social Security Administration is about to make the same mistake as the VA unless we stop it right here and right now. And if this regulation is not repealed, the agency has informed my staff that approximately 15,000 to 75,000 beneficiaries of Social Security may be reported annually, denying them their constitutional right to bear, possess, and own firearms. And that figure of 15,000, or even more so, the higher figure of 75,000, will add up very quickly. In my earlier speech today on this topic, I made clear that the agency regulation is defective in many ways. Namely, the regulation does not require the agency to find a person dangerous or mentally ill. The regulation also provides no formal hearing before a person is reported to the gun ban list. Supporters have also said that repeal of this regulation will interfere with enforcement of gun prohibition laws. Such a position is without any merit, denying people constitutional due process. As I made clear in my earlier speech, important federal gun laws are still on the books, even if the agency rule is repealed. And this is so because this new regulation is actually inconsistent with those existing federal gun laws. For example, individuals who have been determined to be dangerous or mentally ill will be prohibited, as will those convicted of a felony or a misdemeanor crime of domestic violence. The same for those involuntarily committed to mental institutions. While discussing the faults and defects of the rule, I think it is important to highlight that the issues pointed out are also the solution to the problem. If the supporters of the agency rule wants the Social Security Administration to report individuals to the gun ban list, changes need to be made. Individuals must first be determined by a neutral authority after a fair hearing, meeting the requirements of the U.S. Constitution. If they're dangerous and have dangerous mental illness, then they could constitutionally be denied that right. Constitutional due process is a very important part of that process. If we do not act, the agency will erroneously report tens of thousands of people per year to the gun ban list. Not one of them will have been adjudicated to be dangerous after a hearing with due process. Not one of them will have been adjudicated to be mentally ill after a hearing with due process. And all of them will have had the government's burden shifted to them to prove that they're not dangerous in order to get their name off the gun ban list. Common sense, isn't it? You ought to be, you're not guilty until proven innocent. If you can't have a gun, common sense tells me you ought to not to have to prove that you can have a gun to the government. The government's got to prove you should not have a gun. Any way you look at it, the regulatory scheme is patently unfair. If the government wants to regulate firearms, it needs to produce a clearly defined regulation that is very narrowly tailored to identify individuals who are actually dangerous and who actually have a dangerous mental illness. The government must also afford constitutional due process. What we're dealing with here is a fundamental constitutional right backed up by 2 Supreme Court decisions in the last 10 years. With that type of constitutional status, the Second Amendment requires greater effort and greater precision from the government in order to fairly regulate how the American people exercise that constitutional right. This regulation simply doesn't meet that standard. I urge my colleagues to support the resolution of disapproval.